Thank you, Your Honor.
We are live and on the record. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth. Draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Thank you very much, and welcome to the Appeals Court for our session this morning. I'm Judge Milkey. With me are my colleagues, Judge Lemire and Judge Singh. We are your panel on the 5 cases we are hearing this morning. The 6th case is being submitted on the briefs. The first case that we're hearing today is Frederick versus MCAD 2020 P809. I would remind the parties that we have read the briefs. We are familiar with both the facts and the arguments. So I would urge all of you to the extent possible, cut to the chase. And with that, I will turn the floor over to Mr. Ames.
Members of the panel, may it please the court. My name is Brooks Ames. I represent the appellant, Dupree Frederick. Mr. Frederick is watching on the YouTube with great interest. He is 49 years old, married, resides in Boston with his 5 children. He came to this country when he was 26 years old from Haiti. We're here today because Mr. Frederick has a fundamental disagreement with the MCAD about the meaning of the MCAD's charter, which is reflected in Chapter 151B. Mr. Frederick has a fundamental disagreement with the MCAD about the ends that the MCAD can pursue under its charter and the means with which the MCAD can pursue those ends. Let me explain. Mr. Frederick contends that the MCAD is not authorized by Chapter 151B to facilitate settlements of racial discrimination complaints that require only the payment of money to the complainant upon the condition that the complainant enter into a non-disclosure agreement. We maintain that that effectively violates Chapter 151B because Chapter 151B's fundamental purpose and the mission that it gave the MCAD is to eradicate discrimination. And by facilitating a settlement that simply dismisses a claim based on a payment of money in a non-disclosure agreement, the MCAD is not effectuating its mission.
Attorney Ames, can I ask you, how is that an actual controversy today?
It is a controversy today because the means with which the MCAD effectuated that settlement was a violation of Mr. Frederick's rights and entitles Mr. Frederick to the voiding of that settlement agreement, which would put Mr. Frederick back into the position he was in prior to the settlement and give him the opportunity to pursue his claim.
Is there no statute of limitations as to this? It seems to me you're seeking a declaration of rights. And I'm wondering, could this be brought 10 years from now? Is there no statute of limitations governing this?
There is no statute of limitations within the administrative procedure of the MCAD. In this case, for instance, the MCAD, the complaint was made in 2006, but there was no conciliation process that began until after the statute of limitations on the underlying claim had run. So the MCAD is not bound by any statute of limitations in terms of its pursuit of the claim. With regards to Chapter 151B, it is the case that after 3 years passes, your ability, the claimant's ability to go to court is barred by the statute of limitations. But In this case, Mr. Frederick still would have a live claim because the federal law is different under Title VII, meaning that under federal law, if you go first to the MCAD and the MCAD ultimately denies your claim, you may, within 90 days, file a federal lawsuit. So that claim would be alive in the event that the court were to issue the declaration we're asking for, which would void the agreement and put Mr. Frederick back in the MCAD where he was before the settlement and the dismissal.
But counsel, go ahead.
But to get declaratory relief, you need to establish that the declaration is not simply with respect to your case, but that you're dealing with an issue that's repeated. Is that right?
Yes, Your Honor.
And how have you established that this is a repeated issue and this does not apply simply to your particular circumstance?
This is a repeated issue because of the position the MCAD has taken, which is that the conduct of its commission counsel is effectively the practice of the MCAD. In other words, the MCAD has essentially conceded that it believes it is a proper role and end of the commission counsel to facilitate settlements based on payment of money and non-disclosure. That's an accepted practice of the MCAD. The MCAD has effectively conceded that its commission counsel do not have to alert claimants that they do not have any attorney-client relationship with them, and that they are not representing their personal interests. The MCAD has said that that is effectively its practice. So those two practices, those two positions of the MCAD are ongoing. The MCAD continues to assign commission counsel to claimants, and the MCAD presumably continues to take the position that MCAD counsel is not required to disclose that they do not represent those claimants' personal interests and have no fiduciary duty to them, according to the MCAD. So that's the continuing controversy.
Counsel, don't you have a more fundamental problem, namely that your client signed off on the settlement?
Well, my client signed off on the settlement, but under false pretenses. He was told by what he believed to be his lawyer, who he believed to be representing his best interests, that he ought to sign the agreement. He only found out later that—
But didn't the paperwork that he signed suggest that he get a lawyer to review this?
Well, I think in this context, we have a person who has a high school education, who came to the United States from Haiti, who's working as a laborer in the Parks Department. And it's unfair to suggest that a piece of writing in the agreement that says you can seek a counsel to review this agreement with you changes his position, when his position is he has a counsel, which is the MCAD, the commission counsel that's been, according to him, representing him throughout the proceedings. So it would take a fairly sophisticated person to understand that the lawyer representing him actually isn't representing him, and he needs to get a second counsel to tell him what the meaning of the settlement agreement that's been presented to him is.
The ongoing controversy is the continued or the failure to eradicate discrimination, or the use of the MCAD's counsel to conciliate, or both?
It's two things. It's the practice of using non-disclosure agreements to dismiss cases without any relief in the public interest. And two, it's the practice of not disclosing to claimants that commission counsel do not represent them.
And how is the initial one of using the non-disclosure indicated that it's ongoing?
Well, it's an inference drawn from the fact that the MCAD has maintained that it has the right to continue that practice.
All right, but as far as you know, it was only in this case that it was done.
I think that the MCAD has, well, I'll have to hear from the MCAD, but I believe that it's an ongoing practice.
And wasn't there something in the record that indicated that in addition to the payment that the town had addressed the issue of discrimination in that particular claim?
Your Honor, I don't believe that's the case. In fact, we contend that after Mr. Frederick made this complaint, and after the MCAD found probable cause to sustain it, and this was a complaint that said that he was subjected to the N-word. It's a complaint that led to him being admitted to a psychiatric hospital for a period of days. After all of that, a similar incident occurred in which a firefighter had the N-word used on a voicemail. That case has been decided recently by the Supreme Judicial Court, which determined the town's response to it was woefully deficient and insensitive. So it's not the case that in this record, in this complaint, that the town had taken some steps to address the underlying issue of a racially hostile environment. In fact, the evidence would suggest that they hadn't, particularly the evidence that the Supreme Judicial Court looked at in Brookline versus Alston, which just came out last Tuesday.
Can I ask you if we were to find that the complaint should not have been dismissed, as a practical matter, how does your claim proceed?
It would proceed, it would be sent back to the MCAD. The MCAD has indicated that it would dismiss it, but they haven't done, that's hypothetical. So the MCAD would have to take it up. And if the MCAD chose to dismiss it on the grounds that, for instance, that Mr. Frederick wasn't accepting a reasonable settlement offer, then Mr. Frederick would get a notice to sue letter, 90 days, and he would have the opportunity to file a complaint in federal court. It's not uncommon that Title VII claims are made more than 3 years, which is the 151B statute of limitations, more than 3 years after they're initiated in the MCAD.
I guess I was speaking more as to how does it proceed in the trial court? That you're a declaratory judgment action.
I apologize, Your Honor. Yes, there are some factual disputes that would have to be sorted out by the trial court. Once they may be sorted out in discovery, it may require a trial. But once those factual disputes are sorted out, then the trial court would enter a declaratory judgment voiding the agreement and sending it back to the MCAD. That's how I anticipate it would proceed.
But the judge would still have to make not simply a determination of what happened in this case, but because your claim for relief is for declaratory judgment, she would have to make a ruling as to the rights of the parties, the rights of the parties, the status of the MCAD policy. Is that right?
Yes, it would effectively be a declaratory judgment that said for the world, the MCAD may not pursue these ends through these means, effectively, the ends being the non-disclosure agreements, payment of money on that practice, and the means being the use of commission counsel without disclosing to claimants that they're not personally representing them.
What is it that imposes a duty on the employees of the MCAD?
The charter itself requires them to protect the interests of the claimants who come before them, who are victims of discrimination.
No, but for example, the law is clear that MCAD can decline to prosecute a case and that does not give people in your client's position the right to sue MCAD for failing to prosecute a case. Given that, what imposes a duty with respect to someone whose case they do prosecute, but resolve in a particular way?
What the duty is found in due process, among other things. That Mr. Frederick had a right, a due process right in his claim. He had a property right in his claim. And once he has that right to have his claim, his discrimination claim, fairly decided, the MCAD has an obligation to treat him fairly and not to extinguish his right through false pretenses, which is what we maintain happened. That distinguishes Mr. Frederick's case from a case in which the MCAD chooses, say, to dismiss the claim outright. That's not what happened. If the MCAD had chosen to simply dismiss the claim outright, after, of course, finding probable cause, Mr. Frederick would have had the right to pursue his claim in state court or federal court. His claim would not have been extinguished by the MCAD. So here, the difference is that the actions of the MCAD are extinguishing his right.
Okay, counsel, your time has expired. Let me see if my colleagues have any follow-up questions. Seeing none, thank you very much. We will hear first from the commission. And I understand the two appellees are splitting their time 10 and 5.
Good morning, may it please the court. My name is Deirdre Hostler and I'm here on behalf of the MCAD. I'd like to make clear first and foremost that the MCAD did not answer the complaint in this case. The MCAD filed a motion to dismiss for want of subject matter jurisdiction and failure to state a claim. The MCAD has not answered what its practices and procedures are. It has instead said that the allegations as raised in the complaint are wholly insufficient to haul the MCAD into court to answer for what its practices and procedures are. Because what this case does is it asks us to travel 9 or more years back in time to look at what are discretionary actions by the MCAD in a discrete fact-bound situation where there are totally insufficient allegations of injury of any kind. You cannot use the Declaratory Judgment Act to attack an agency in this way. There has to be an actual controversy and there has to be standing. The timeliness of this case alone requires its dismissal. The allegations are about a former employee's conduct, allegedly fraudulent conduct, 9 years ago in the settling of one case. The statute of limitations for any underlying fraud or tort claim are long past due, and the MCAD is entitled to the closure that statutes of limitations provide. It cannot fairly be asked to answer 9-year-old intentional tort allegations, excuse me, in the context of a Declaratory Judgment Act.
But can, in the context of the Declaratory Judgment Act, can the agency be asked to answer as to whether it complies with its own mandate, with its own charter, with its own regulations? Separate and apart from what happened in this particular case, shouldn't there be an ability to question whether the agency complies with its own charter?
Broadly, yes, but not in the context of this case. I mean, the plaintiff has to make sufficient allegations that invoke the need to examine that. And the plaintiff has not done this in this case because he has an old grievance about how one case was settled at the MCAD. Simply put.
Counsel, it's uncontested, isn't it, that the settlement here included an NDA?
That's correct.
How is an NDA consistent with the public records statute?
Well, settlement agreements are between the parties, Your Honor, and that means the respondent and the complainant. The MCAD is not a party to that case.
Do they sign the settlement agreement?
They do not. We do not. No, Your Honor, we do not. And just to be clear on that point, we certainly have not answered in any way, shape, or form that is a common practice of the MCAD to negotiate a non-disclosure agreement. Getting back, however, to the untimeliness, I'd like to emphasize that not only are plaintiff's allegations about untimeliness trying to get around the statute of limitations totally implausible, but they're also really importantly incomplete, because half of his allegations are about relief that commission counsel was supposed to have ensured was in the settlement agreement, but he doesn't have any excuse in his complaint, any allegations whatsoever, for why he didn't notice that at the time. The relief that was attendant to his settlement agreement was obvious when he signed it. So that allegation is clearly 9 years old, and there's no getting around the entire.
Okay, but just assume hypothetically there wasn't a timeliness issue. Say he had noticed what he considers a problem, indeed, from his view, fraud, a week after the settlement was signed. So there's not a timeliness issue. What would you be arguing in that situation?
Well, we'd be arguing exactly as we did, that even if timeliness were not a problem, we're still talking about discretionary acts, and we're still talking about allegations that are insufficient to allege a consistently repeated practice at the MCAD. So even putting timeliness aside, at base, plaintiff is attacking what are discretionary acts by the MCAD, because his argument about the MCAD mission and obligations under the law are twisted and contorted. The chapter 151B section 5 and MCAD regulations do not in any way, shape, or form require a specific type of relief that must be in every settlement agreement that's signed when a case is pending at the MCAD. It's just not.
Why aren't you arguing just straight waiver? He signed the settlement agreement. The settlement agreement itself says so he should get a lawyer to review it. End of story.
Those are all true, Your Honor. But at the end of the day, the settlement agreement is not something that the MCAD was a party to. The MCAD is moving to dismiss the case because its practices and procedures are being challenged in a totally insufficient way. So at the end of the day, whether or not the parties have a settlement agreement between them is not something that directly affects the MCAD. But it's nevertheless true that he signed a voluntary settlement agreement, and he should be precluded from bringing both the town of Brookline and the MCAD into court 9 years after the fact of having done so.
So you say MCAD was not a party to the settlement agreement, didn't sign off on it, but was it not negotiated through MCAD counsel?
That's true, Your Honor. So commission counsel do facilitate settlement between the parties. This case initially failed at what is the conciliation meeting that happens, which is an obligation under Chapter 151B. The MCAD is required to conciliate cases once a probable cause issues. But from there's no mandated result from a conciliation. So when the conciliation initially failed in this case, the parties, continued to negotiate, and commission counsel was part of that. But I'd like to say that, not only has plaintiff not brought up a real dispute with regard to what the MCAD is required to do under its mission and its statutes, but the MCAD, wants to be heard as strenuously objecting to these arguments that it does not live up to its mission, that it's unfaithful to its mission. As I mentioned, we are required to conduct conciliations once probable cause issues, and the agency does so uniformly. There are no allegations that are sufficient to have us question that the MCAD doesn't often secure affirmative relief through the use of commission counsel or otherwise. And further, this idea that conciliation and settlement agreements between the parties isn't in furtherance of eradicating discrimination is just wrong-headed. The legislature clearly believed that conciliation was a proper role for the MCAD in getting the parties to settle the claim between them, and that advanced its mission in the public interest. So,
a lot of claims that begin at the MCAD end up in one of the trial courts with a civil lawsuit. So I assume that's the purpose of the conciliation, to bring an end to the claim under various aspects, whether it's the discriminating practices and or some compensation for the harm that they may have instilled on somebody. So in other words, it's not inconsistent with resolving a potential claim because it doesn't necessarily end at the MCAD. In other words, claims that begin there don't necessarily end there. Conciliation helps them to end there.
That's correct, Your Honor. That's correct. Yes. It bears mentioning with a little bit of the time that I have left, however, just that standing is woefully lacking in this case. To the extent that plaintiff alleges any injury whatsoever, it's entirely speculative. He appears to believe that he has, he's guaranteed to win his case if he moves forward. That is not true. Neither is it true that he would secure any additional amount of monetary damages than what he voluntarily agreed to. And importantly, he has not alleged a specific duty to him owed by the MCAD, as opposed to the MCAD's more broader duty to the public interest. So I'd like to conclude by saying that there is no actual controversy between the MCAD and the plaintiff. There never was when the parties signed the settlement agreement, and there isn't now. And with that, I'll rest on the rest of my arguments in the brief.
Do either of my colleagues have any further questions? No. Thank you very much. We will hear from the town.
Thank you. If it pleases the court, Doug Lewison on behalf of the town. And I will not restate the arguments of the Attorney General's office relative to the issues relating to the MCAD, but rather direct my time to the separate argument contained in the town's brief that appellant seeks not only to renew an action or bring an action against the MCAD in this declaratory judgment, but importantly, which should not be lost on this court, is the appellant seeks to renew and rescind this arm's length good faith settlement agreement between he and the town. And that's very important. This is not just a declaratory judgment that the plaintiff or the appellant seeks to proceed with, but to renew a case that was settled over 9 years ago in good faith with the assistance of the conciliation, as counsel referred to, but continued negotiations through the counsel's office for the MCAD and town council. And nowhere is there a legitimate or law-based argument by the appellant that he is entitled to rescission of this agreement 9 years later. There is no allegation made because there was no fraud or misconduct on the part of the town, who is the signatory and the party to this settlement agreement. The settlement agreement is attached before the court, both in the brief and in the appendix. And the court, the judges were correct in saying the MCAD was not a signatory. Only the parties, the town and the appellant were signatories to this settlement agreement. The appellant's argument and brief and today's arguments is devoid of any legitimate argument to say he should be allowed to reach back 9 years and rescind a good faith settlement agreement between those two parties. The cases cited by appellant argue in favor of the town. And while not agreeing by any stretch that there was any misconduct or fraud on the part of the MCAD or its general counsel, I think it was very clear and understood that the counsel was not representing the appellant. But there is no allegation and no law supports appellant's position that misconduct of a third party, which would be the MCAD or its counsel, is the basis for rescinding the contract or the agreement between the town and the appellant.
Let me ask you this. If, let's say the plaintiff did have his own counsel and his own counsel betrayed him, you would say even then, because the town was acting in good faith, even then there would be no cause for rescission?
I would say that, Your Honor. 9 years later, he might have, or 3 years after the agreement, or perhaps when he learned of the fraud, he might have a claim against his counsel. But he has no claim because there is no claim of misconduct or fraud on the part of the town. And when you see the cases that speak to rescission of a settlement agreement, it's because of fraud on the part of the other party in that agreement. And there is none, and there were none, and there was no allegation of fraud on the part of the town here. So it is unsupported in the law to suggest that 9 years later, an agreement which was arm's length and in good faith.
Well, you keep bringing up 9 years later. Let's keep it, let's take the time factor out of it. You're saying even if this was let's say the betrayal by his own attorney was discovered a week after the fact, that it still would not provide a basis for rescission.
That's correct, Your Honor. In every case cited, and I make reference to those cases at pages 21 and 22 of the appellee's town's brief, the cases all refer to the fraud has to be on the part of the counsel for that party, and then the action is only against that counsel. It still does not serve as the basis for rescinding this agreement where there was no fraud by the party to the agreement. And in fact, it was ratified by the appellant's own conduct. Money was paid in support of this agreement. The money is still held. The ratification of the agreement, the appellant has never returned that money, which is a ratification of the agreement. And I also know Justice Singh's argument about taking out the time factor. Built in or baked into the agreement was a 21-day rescission period within that agreement. So, I mean, it's a hypothetical example you use the week later, but we built in that kind of contemplation. And so, as the record is established, there was whatever basis the appellant had to try and rescind it was inadvertently attached and given to him 9 years later. And it is just bad faith and bad law and no basis.
Counsel, your time is up. I have one quick question, which is how is the NDA aspect of this agreement consistent with the Public Records Act as it applies to the town, and for that matter, just public policy?
Well, I don't think it impacts the issues before this court. I'm happy to answer it. It may be that the parties agree to not disclose it. That doesn't preclude a FOIA request to the town because the litigation is closed. So an NDA may not ultimately be enforceable, but it's not against policy to ask for it, but it doesn't necessarily preclude a subsequent or a third party seeking that from the public entity. But that in no way you could carve out that NDA. It doesn't render this agreement fraudulent or
okay. Do either of my colleagues have any follow-up questions? Seeing none, thank you all very much. The case is now on
the record.
Thank you very much. We are back on the record for our second case of the morning. That is Smith versus Accurate Collision, Inc., 2020 P554. I will remind the parties that we have read the brief, so we are familiar with both the facts and the arguments. So that I would ask you both to the extent possible, cut to the chase. And with that, I will turn the floor over to Ms. Johnston.
Good morning, Your Honors. I'm Attorney Ann Johnston. I represent appellant Howard Smith. He was the former owner of a Maserati, which was the underlying property that was at issue in this matter. This should have been a simple matter. It was basically a motion to dismiss brought by appellees under Rule 6 or 8. And it was a very straightforward factual matter. This was a different accident. It was not the same accident as a district court case. The district court case was a matter involving rear end damage in what we called a fender bender.
But counsel, we know the arguments, but wasn't the original district court complaint, didn't that include an allegation that the car was damaged in the care of Accurate?
It included the rear end damage only, which was in the fender bender in the parking lot of a strip mall.
No, but wasn't there an allegation that after the car went to Accurate, it suffered damage there?
Not in the context of the district court case. The Superior Court case brought that issue of it happening afterwards, because after we got the car back from Accurate Collision, we discovered new damage that was it was not even known at the time of the district court case.
Can I ask you what, in your first complaint in the district court, paragraph 28 of the complaint says plaintiff has reason to believe the defendants had an accurate collision, have further damaged the vehicle in order to increase the cost of repairing the vehicle. How is that?
That was based on rumor only. We did not have any facts of that. We did not have any proof of that. We did not have any
You alleged it in the district court complaint.
As a rumor to be proven only. It was not anything we had concrete information about.
But it was part of your complaint.
It was part of the complaint in that we anticipated, based on rumor, that there may be some additional damage, because you
don't allege it to be rumor. You said you have reason to believe.
That's correct.
So it is part of the complaint in the district court.
It is, to the extent that we were concerned, because we were hearing rumors, and it was strictly a rumor, that there was some additional damage. And again, this was where we were going from $4,000 to $7,000 worth of damage. Suddenly, once we got out of the district court case, it became $34,000. That was basically the Superior Court case, was involving the total destruction of the car. When we were in the district court case, we were dealing only with the rear end damage. That was a bumper, the tire, the trunk was misaligned, the right taillight was broken. Those are the total extents of the damages we were dealing with in the district court. When we got to the Superior Court, we were dealing with the complete and total destruction of the car. The side panels were taken off. The undercarriage was damaged. The front end was damaged. There was no damage to the front end when we were in the district court. There were parts that he ordered as part of the district court that we proved in the district court were not part of the damage, but that was it. I mean, he had ordered some parts that had nothing to do with the damage that we were experiencing in the district court, which was the rear end.
Counsel, to the extent you're arguing that your client learned of new facts, the additional damage after receiving the car back, why wouldn't that be an appropriate opportunity to file a Rule 60B motion as opposed to filing a whole new complaint?
Well, one was jurisdiction. With the destruction of the entire vehicle, the damages had increased significantly. They went from being a small, maybe $50,000 to a couple of $100,000, which in those days was too much for the district court. Under present circumstances, it would have been capable of going back to the district court, but it was not at that time. And so in that context, we went to the Superior Court. And this was also a matter where the client was feeling more and more uncomfortable with the microaggressions that were happening in the Worcester County courts. I'm using the word microaggression as defined by Isabel Wilkerson in her book, Caste, meaning race, privilege, class or caste, and technology, which is part of privilege and class. He was feeling more and more uncomfortable with the district court, so we shifted to the Superior Court because we had both jurisdiction and we had enough damages that we needed to be there.
Is there any light you can shed on the unusual aspect of this case, namely the dropping of the counts against Accurate when the complaint was amended in district court?
I didn't drop them. That was the view of the judge in the district court. He and I disagreed about that. I had on paragraph 6, I had a very, first of all, the title of the amended complaint was adding Commerce Insurance Company. It was not starting from scratch. It was simply adding another party. And there was also a paragraph that expressly incorporated and merged all the counts of the first complaint. He disagreed with me on the interpretation of incorporation and merger. He did not feel that that merged the original complaint into the second amended complaint. My understanding of incorporation and merger by the straight definitions of it means incorporating in full as if set forth in full. So yes, all our complaints in the first complaint were in fact incorporated into the amended complaint.
So did you have an opportunity to appeal the erroneous findings or the erroneous rulings by the judge?
We could have. Again, my client did not have the money or the wherewithal to do many of these activities that the district court judge had suggested. This raises an issue that, again, comes up in the district in Worcester quite frequently, which is, again, the issue of microaggressions. My client is Black. He was a factory worker. He was not a suit and tie type gentleman. He did not have the ability to do all these things. It was not until after we got to the Superior Court and I took on the case as a contingency fee matter that we were able to pursue this appeal. It is a difficulty that anybody who is not of business background or financial background will face in dealing with consumer protection cases.
So, counsel, just so that I make sure I understand it, you handled the case in district court. It's just that it wasn't then on a contingency fee basis? No,
it was not. It was a straight hourly wage, and the 2.5 day trial used up every penny he had. And I was then put in the position of dropping out or going forward. Since I believed in the Consumer Protection Act, and since I did believe in my client, I took on the case as a contingency fee case, and I've been fighting this for the last 5 years. Appellate counsel at the moment was not trial counsel in any of the courts below in Worcester. I've been through 4 lawyers and in 2 courts in Worcester. We have tracked Mr. Haddad through many attorneys, many courts. Let's see, Middlesex, Norfolk. I think we may have tracked him to a case in Bristol, but we've tracked him through many cases. And in fact, your court heard him last month in one of your sessions with his ADH auto body shop, which is his.
A lot of that is outside of the record here, so I'm not sure where you're going with that.
Well,
so
the point
if
is,
we could limit it to the record here, I'd appreciate it.
Well, the point I'm trying to make, Your Honor, is he has used and abused the court system significantly in order to get his way. And he's had a long-standing fraud and fraud scheme, extortion, fraud, and manipulating. He's recently been in front of your court on another thing. He uses the courts to get what he wants. And the
But we're
courts,
here on a procedural issue of whether or not you properly filed a complaint that was previously filed in the district court, whether the subsequent complaint in the
that decision was resolved. We won. The judge did not see fit to award any finances at all in that case. And we then proceeded on to when we got the car back and realized that there was significant damage to the front end now, the underbelly, the tires. The tires were the razoring of the tires was the most significant damage we found. They could have easily have blown, even possibly killing somebody, because every single tire was very carefully razored. So in that context, we then went back to the Worcester court because that was the appropriate jurisdiction, because my client is a Worcester resident, and we went to the Superior Court. At that time, they filed as a weapon, not as a sincere motion, but rather as a weapon before any discovery had been conducted. They filed a motion to dismiss. That is not the correct usage of the motion to dismiss. A motion to dismiss is to establish that there is no plausible relief on which you can be awarded. We presented a plausible relief. That was a totally different accident. We went from the rear end, we were now talking the whole destruction of the vehicle. That's not the same. It's a different time frame. We don't know precisely when that time frame happened. We do know it happened while it was in the custody of Mr. Haddad, but we don't know when. It may have happened.
What prevented you from discovering that while you had the district court action pending?
I'm sorry?
What prevented you from discovering any damage, which you somewhat aware of based on your district court complaint? What prevented you from discovering it during the pendency of the district court action?
We could not inspect the car.
I understand you were given the opportunity.
We were given the opportunity, and conveniently or accidentally, a door came down on Mr. Smith, and as a consequence, we did not get to complete the inspection. The car was blue wrapped, as they described it, so you could not see anything of the car when we were there.
Did you attempt to go back?
We did. We tried to contact and organize another inspection, but by that time we were in the district court, and they finally ordered the release of the car.
Oh, but prior to trial, did you file any motion to inspect?
I'm sorry?
Prior to trial in the district court, had you filed any motions to inspect?
Yes, we had.
And the result was your client was injured. Did you file any further motion?
I believe we went back to the court and tried to get a bond so that we could see it that way. But then my client could not afford the bond.
But why would you need a bond to inspect the vehicle?
Because Mr. Haddad would not release the vehicle. You can't just walk into an auto body shop and look at a car. You have to have the permission of the owner or the auto body personnel to look at a car, and they would not let us look at the car.
And again, you could have asked the court for an order.
We did, and the judge eventually gave us that. We started with that approach, which is just let us have the car. That's how we started this whole process.
I'm just asking about the inspection, not the possession of it.
Again, to inspect a car, you have to have enough of a possession that you can inspect it. You can't just walk into an auto body shop and inspect the car. You have to have the owner's permission to do so. He was not cooperating with us and would not let us review the car, inspect the car. We went to eventually we got the order from the court allowing us to inspect the car. But unfortunately, Mr. Smith was injured, and so we did not get to finish that inspection.
Anything further?
I'm sorry?
Anything further?
Yes, I mean, this is a case that I wouldn't say it took on a life of its own. It did not. We had gone to every agency we could think of. And eventually, the different agencies, the Department of Justice, the Attorney General, the IRS, eventually all those people, we went to all these agencies hoping to expose the fraud scheme that Mr. Haddad was executing on the public. And eventually these parties got involved publicly involved in about 2020, maybe late 2019.
Okay, Counsel, I'm afraid your time has expired. Do either of my colleagues have anything further? Seeing none, thank you very much. We will hear from Attorney Brosnan.
Good morning, Your Honors. May it please the court, my name is John Brosnan. I represent the defendants, appellees, Accurate Collision, and Adam Haddad in this case. I think Judge Ritter got this exactly right. This is a classic case of claim splitting. Before I get into that, I point to also, I know Justice Lemire talked about paragraph 28 of the district court complaint, but paragraph 18, which is at RA 57, specifically states when plaintiff Smith next saw his Maserati, it had been further damaged by the defendants from the time he originally left it with defendants. You've got the identical parties, you've got the identical claims. There's this odd little procedural twist where Mr. Smith made a fatal error in the district court when he amended his complaint to add commerce. He omitted any complaint claims against Mr. Haddad and Accurate Collision. The only claims in the body of the complaint, as the district court found, were against commerce. And I think Judge Lecanto, in the ruling that's included in the supplemental appendix, said, hey, look, all you had to do was come before me and say, I want to amend the complaint. He said he would allow it. Amendments to complaints are allowed liberally. But unfortunately, Mr. Smith dug his heels and said, well, we disagree with Your Honors. They didn't give the court any chance. So all of it was tried in the district court were the counterclaims, but of Mr. Haddad and Accurate Collision.
Can I ask you on the splitting, claim splitting? A number of the cases that I read that were cited in your brief deal with two pending cases. In other words, they're simultaneously pending. That's not the case here, correct? In other words, the district court case was resolved, was over when the Superior Court case was filed. So, I mean, the language is pending, another prior pending. Does that restrict the claim splitting to cases where there are two pending at the same time in two different courts?
Yeah. Let me try to answer that.
Do you understand my question?
Absolutely. Yeah. The procedural posture was the appeal from the underlying judgment on the counterclaims was dismissed because they failed to properly perfect the appeal. There was a pending motion for a new trial filed by the defendant appellees that was dismissed on June 8th of 2018. At that point in time, under Rule 4, it was incumbent upon Mr. Smith to file another notice of appeal. The original notice of appeal was a nullity. On July 20th of 2018, we then filed a motion to dismiss the appeal. On August 1st, the court heard argument on that. On August 16th of 2018, the court allowed the motion to dismiss the appeal. Thereafter, Smith files a second notice of appeal. In September 2018, he requests the transcript. And on February 21st, 2019, he files a motion to extend the time for appeal. That was pending at the time the motion to dismiss in the Superior Court was heard on February 26th of 2019. So there was this last little vestige of the case that was still pending. It wasn't until no parties received notice on March 27th of 2019 that the request for an extension of time to appeal had been denied. So I would submit that the case was pending, and Judge Ritter had referenced that in his decision. Even if you take the view that it wasn't two pending actions, then the rule of claim splitting just comes in as a matter of the claim preclusion doctrine. And again, you've got the identities of the parties, you've got the identical causes of action. And in that case, then I guess you'd have a final judgment. It's an interesting question. When you appeal from the denial of a motion to extend an appeal, I mean, I suppose the appeal is limited to whether that was an abuse of discretion by the district court, but there was still a vestige of that case alive. So I would submit that the 12b-9 doctrine still applies. But even if it doesn't, we're talking about classic claim preclusion. These are the identical claims. It's all about Mr. Smith going to accurate collision. He brings the car in on March 2nd of 2016. He brings the car to the shop. Things ensue. He files the first lawsuit on June 24th of 2016. It's the identical claims. He's claiming that fraud, 93A, intentional infliction of emotional distress.
Okay, counsel, but assume for the sake of argument, as we must, that the facts as alleged are true, namely that when Mr. Smith got the car back, he discovered which was at the conclusion of the first case, actually after the conclusion of the first case, he discovered all this additional damage that was significant. What were his options at that point? We're dealing with new facts, newly discovered facts that put aside the inspection issue for the moment. What was he supposed to do at that time?
I think what should have been done is he alleges it in the district court that there was further damage, and he's making allegations of fraud against my client, saying, hey, you guys, a car comes into your shop and then you further damage it. His vehicle in that case is that's the Maserati is the thing at issue in that case. Of course, he has an absolute right to inspect it. He could bring an expert. He could, if it's presented in shrink wrap, you just have him take the shrink wrap off. That he was absolutely within his rights under the discovery procedures in the rules of procedure to fully inspect that.
So is it your position that damage was discoverable during the pendency of the district court action, and the fact that they found it after does not allow them to bring a separate action?
I said exactly. I would say that's exactly right. You can't split a cause of action. You can't go to district court, not try your case in chief and try some counterclaims and then come back and get a second bite at the apple. That's just a classic splitting of the cause of action. That there's just no way you can do that. It's completely unfair to the defendants. There's vehicles.
And is your suggestion that the allegations in the first complaint of further damage are sufficient to have raised that issue? In other words, they're claiming we didn't know how much damage. We didn't know until we actually got the car, and then we saw the razor cuts on the tires and the fenders removed and the other damage. Even though we had suspicion or rumors of that, I mean, is the fact that they knew something at the time of the district court alone sufficient without more to create a claim?
Absolutely. I think the allegation and the complaint was what was further damaged. It's then incumbent upon them to investigate how much further damage was incurred.
Are you saying that there was nothing preventing them from discovering that?
Absolutely nothing. That was the race. That was what the case was about. The Maserati. If someone's now he had multiple options. The court, the defendants asserted a garage keeper's lien. You can post a bond and take the car back. So he had that option available to him. He couldn't.
Why he couldn't afford to post the bond?
Then it was incumbent upon he and his attorneys then to seek an inspection under the rules of procedure under Rule 34. You absolutely have a right to go out and see the property. This is a personal property dispute over a car, a 10-year-old Maserati that was in a shop.
Well, it's counsel. Frankly, it's more than that. They're alleging an intentional fraud scheme, and there's some evidence of that here. So let's not get on our high horse about this is a mere property dispute.
Well, I think at the end of the day, It is, because these damages that are being claimed are not even anywhere in the ballpark reality. The measured damage in a property damage case is diminution in value before and after the accident. So we're talking about a $30,000 claim at the outside. So, but getting back to the facts, I mean, they had the opportunity to inspect the vehicle. If you look at the judge's decision, he made a finding on denying the counterclaims that and evidence was presented about additional damage to the vehicle. He found it was dismantled by accurate more than it should have been. It's just not fair to give Mr. Smith a second bite at the apple on claims that he failed to properly prosecute in the district court. There has to be some sense of finality.
There's some record of Mr. Smith receiving $6,000 and some odd dollars from Commerce.
That's correct.
Was that the only insurance payout that you're aware of?
That's the only one in the record. There may have been a subsequent payout after he retrieved the vehicle, but it's not in the record, and I don't have the information on that.
Now, counsel, say there was an intent, and I hope to inspect the car through informal processes in the district court, but your client made it difficult, as a matter of fact, to actually come in and examine the car. Under circumstances where they discovered a fair amount of additional damage, why couldn't they have pursued, for example, a 50B6 motion or a 50B whatever motion in the district court to say, Your Honor, the facts are changed. We could not have discovered this in a practical sense, or they made it difficult for us to do that. We want to reopen the judgment.
Yeah, they had multiple appellate avenues in post-judgment recourse. They didn't do anything. They could have brought a Rule 52 motion to amend because it was a tried jury waive, so they could have brought a Rule 52 motion to amend the findings of fact. They could have sought to amend the complaint. They never did anything. They didn't take an interlocutory appeal, and they didn't properly perfect the appeal from the judgment. Additionally, they could have brought Rule 37 motions for sanctions if they felt that their right to inspect the vehicle was being impeded. You'd go into the Worcester District Court, it would be automatic. You know, if they're saying that we're impeding the inspection, the court's going to obviously allow them to inspect the car, and perhaps, you know, you could have someone watch the inspection. I mean, it was there for them to discover. It was incumbent upon them to pursue their claims. They made the allegation that there was additional damage that occurred, and that the additional damage was part of this alleged fraudulent scheme. So they should have been much more aggressive in pursuing the remedies. And then, of course, they had appellate avenues available to them. And of course, the whole thing would have been rectified if Mr. Smith, when he showed up for trial in January of 2018 and said, hey, here's my amended complaint, I'd like to amend it. And the court, Judge Lecanto specifically said he absolutely would have allowed it. So I think it's incumbent upon Mr. Smith to have taken all these actions that he failed to take. It's not fair now to come back and say, okay, I want a do-over. The law is crystal clear on that, on claim preclusion and under 12b-9.
You have 2 minutes left, as you can use, or?
Yeah, if you have any questions, I'm happy to. I think I've touched on all the points I wanted to make. If anyone has any other questions, I'm happy to address those.
Seeing none, counsel, thank you both very much, and the case is now submitted.
Thank you very much.
We are live and on the record.
Thank you very much. We are back on the record for our third case of the morning. The case is a DCF case, 2020 P1117. I would remind the parties of two things. One, the case is at least partially impounded, and please do not use any of the names of the parties. Status will be fine, such as mother, older daughter, younger daughter. And secondly, I just want to remind everyone that we have read the brief, so we are familiar with both the facts and the arguments. So since we do not have a great deal of time, I would urge everyone to cut to the chase to the extent possible. And we will go first, I believe, with Attorney Kaiser representing the two children. And I understand the time split is 10 minutes, 5 minutes. So Attorney Kaiser.
Good morning, Your Honors. My name is Jean Kaiser, and I represent the appellant children who are challenging the termination of their mother's parental rights. The older child will be turning 14 a week from today, and the younger child is now 10. This is a difficult case, and it required the juvenile court to pay careful attention to what was best for these children. The children challenged the court's order terminating their mother's parental rights because, in the words of DCF's own trial counsel, it renders them orphans and therefore does not serve their best interests.
Counsel, could you comment on the development of your client's position from the trial court to here? Because the transcript in this case is very short, and it's hard to find in there where the children were opposing the termination of the mother's rights. And so there aren't, frankly, a lot of arguments that this was not in the best interests of the children.
Correct, Your Honor. And I noticed in DCF's brief, it characterized the children as having changed their position. But I don't believe what really happened here is a change of position. While the children's trial counsel did not expressly articulate that the children opposed the termination of their mother's rights, he did articulate that the children opposed adoption, particularly the older child, who said consistently and insistently that she would not consent to her own adoption. Now, termination of parental rights is a prerequisite to a goal of adoption. So when I evaluated the children's position for the appeal, I did speak with the children and determined that their position in this case is as appellants and not appellees.
Okay, but the older child can veto adoption. I mean, that is clear. But in terms of the best interest analysis, why isn't it sort of a self-serving, not self-serving, self-fulfilling is the word I want, prophecy that, she's not going to be adopted if she opposes adoption. There's no question that the mother is currently unfit. No one's arguing to the contrary. These children are not unadoptable in the sense of, frankly, some of the children we do see in these contexts. And it raises a difficult question, the extent to which we should just say, well, because she doesn't want to be adopted, therefore what?
Well, under Massachusetts law, it is, in order to terminate parental rights, there has to be two conditions. First is parental unfitness, but second, the decree must serve the children's best interests. So here, looking at the children's best interests, there's very little in the court's decision, either the findings or conclusions of law, that speaks to in what way this decree that cuts off all hope of the children ever being able to have a relationship with their mother serves their best interests, when it would be so difficult to overcome what look to be insuperable barriers to adoption. It's not just that the older child has consistently said that she won't consent to her own adoption, and as you said, can veto her own adoption. So how does a permanency plan that essentially plans to have this child who refuses to be adopted, how does that serve her best interest? But there are other barriers as well. These are older children and therefore less likely to be adopted. These are a sibling pair. Does it serve their best interest for them to be separated? The younger child, at least at this point, cannot veto adoption, although she opposes it. And so does it serve their best interest to separate them so the younger child could be adopted?
But if the mother's rights are terminated, then there's a huge potential upside in terms of adoption. I'm just speaking personally, struggling with finding what the children lose by termination. You say they lose any chance of the mother playing a part in her life. Is that necessarily true in terms of, to the extent the mother is able to turn her life around, at a minimum, there's nothing preventing DCF, the current holder of legal custody, from allowing visitation with the mother. And frankly, you know, in the event there was a complete turnaround and there's no one else ready, willing, or able to adopt, you could see the mother stepping into that role. So I'm not sure your premise is necessarily correct.
Well, Your Honor, I think this case involves the weighing of benefits and risks, right, as you said. And the fact is that once the if this decree is upheld, then the mother no longer has any right to get in touch with the children. She doesn't even have any right to know where they are. Her rights are terminated. Her relationship with them is ruptured. And DCF does not need to work with her. Her rights are terminated. And so therefore, yes, is there some hope if, you know, the children remain in foster care and the mother reappears and somehow finds the children? Is there some hope that there could be contact reestablished? Yes, but it's a vanishingly small hope.
But even if the mother loses the right to do that, don't the children still have a right represented by counsel in the review and redetermination process to press for visitation?
The children could do that if they could, but then the question becomes, you know, can the children even find out where she is? What's the psychological impact on the children of having their relationship with their mother legally terminated? And look at what we're exchanging it for. We're exchanging it for, you know, DCF in its brief does point out, you know, that it's been a long time with the mother, you know, and she hasn't gotten it together to this date. And it's an illusory hope that she might be able to care for these children again, or even have a relationship with these children. But I would assert it's a similarly illusory hope that somehow these children who oppose being adopted, who won't cooperate or participate in any recruitment efforts to get them adopted.
Now, at the time of trial, the older daughter was about to enter therapy. And the therapy, there's something in the record that suggests that therapy was going to address the potential for adoption. Why should we take it as just a firm assumption that the older daughter is going to veto any adoption? We do know that if the rights aren't terminated, that effectively precludes any adoption.
That's correct. It does preclude any adoption, at least at this time. However, and I think it's always a difficult thing with these cases because the life of the children moves on, right? And the life of the parents moves on after the evidence closes. So things do change. Parents go into recovery. Children change their minds about things. But the children are still here as appellants. And my role as counsel for the children is to be, as any attorney would be, and that is to represent their wishes. And I am here today representing their wishes, which is that they oppose the termination of their mother's rights, and which goes along with their continued opposition to being adopted.
But can't we consider that it's in their best interest to have the potential for termination, to have the potential for adoption, and that just that permanency and stability potential is in their best interest, as compared to unstable, non-permanent relationship with the mother that's been ongoing. In other words, to compare the potential for one over the other as the benefit for the children. Can we
I see
that?
my time is out, but I will.
Please answer the question.
Yes. So I think that there are still other things that yes, maybe there is some potential that the children could change their mind, and somehow an adoptive family could be found despite the children's opposition to participating in recruitment efforts. But then you still have to look at, are the children perhaps best off, and DCF makes this point as well, where they are now. It took DCF 3 years to find a stable placement for these children where they could be together and could be in a place where they were satisfied. The trial court said that she didn't have sufficient evidence to know whether it would cause the children psychological harm to be removed from that very placement. I would say that speaks to a failure of clear and convincing evidence on the part of DCF to show that the decree serves the children's best interest.
Well, but termination is not that. Termination is an abuse of discretion issue. Unfitness requires the clear and convincing evidence. To what extent can we rely on the good graces of the family friend who is, at least at the time of trial, serving as the foster mother?
Well, I think that what we have to do is look at the evidence that was presented at trial. And the evidence that was presented at trial is that she said she would care for the children as long as they needed her.
But we don't know if that was an she did not testify.
She did not.
We don't know if that was an offhand remark or a commitment to be there, akin to the guardianship, which she said she did not want. She was unwilling to commit to, according to DCF.
Right. I think if looking at the testimony, I did not read that as an offhand remark on her part, but rather as a commitment.
But again, it wasn't her testimony.
That is correct.
And I realize this is outside the record, but I'm going to ask you the narrow question: are the children still in her care?
I can answer that narrow question, yes, and I can.
I think we're going to leave it there.
Okay.
Going outside the record.
Okay.
Do either of my colleagues have any further questions? Thank you very much. We'll hear from the mother's attorney.
Good morning, Your Honors. I'm Madeline Blanchette, and I represent the mother in this case. I just want to be clear that this is not a case about the children's best interest yielding to the legal rights of the mother. It's quite to the contrary. The DCF attorney said it himself at the onset of the case that while the termination, the unfitness of the mother checks the box for termination at that first prong, that would be, I think he said, irregardless, like despite the best interest of the children. And that's the interest here. That's the problem here. That's the conflict. And, you know, I think Your Honors asked quite a few good questions. I would say, you know, that that there's so much mythology here that was presented, in like this sort of hopeful way that they could become adopted, when in fact, the very hard evidence is that they didn't even want to participate in identifying anyone whom they didn't even want to be viewed by people who might even be considering adopting them. So, I mean, I think
counsel, the children, and even though the older child now has a legal right to veto adoption, they're still young, okay? And they may not know their best interests. So the extent to which we necessarily defer to the termination question based on the children's wishes is certainly at a minimum an open question, especially when the older child was starting therapy around the time of the end of trial.
Well, Your Honor, I'm glad you brought that up, because I mean, if we talk about that the child is entering therapy, then, who knows what's going to manifest out of that. Then maybe the very real trauma of losing her mother will impact her behavior. And now she'll be in a category that you referred to as some of the children that you see in these cases as unadoptable. So, I mean, if we're opening up the Pandora's box of the children going into therapy, we have no idea where that's going to land us. And most likely there'll be a rockier period. And I think that was, really mother's concern about these permanents, these adoption plans, is that they were extremely vague and superficial. And I think that was probably largely in part, like Your Honor said, that there's been this long delay getting the children to therapy. And, that is not something that,
But counsel, we do know that were we to vacate the termination decree, that the children are unadoptable at that point, by definition. So turning to, what is it? How is the termination against the child's best interests in a circumstance where there's no question of unfitness, and where, frankly, your client didn't have any significant role ongoing in the children's lives?
Well, Your Honor, I think that the fact that the children would still have a legal parent out there and not be in this horrendous purgatory of being a legal orphan, and that their mother would still have counsel, their mother would still have standing to participate in permanency plans and foster care reviews, even in terms of this other path, which I think was the most clearly expressed interest of the children, which was that a more kin would come forward. I mean, just to have that other person there represented by counsel with standing, able to identify like, oh, there is this cousin and so-and-so just moved up from Florida. I mean, right, if this termination is affirmed, I mean, then the children are down to zero. I mean, then they've got the state and that's it. And, mother would argue that
they would still have an attorney, correct? To participate in any permanency planning and review and redetermination.
They would have an attorney, and they would have no adult or kin who's represented by counsel who could advocate for them or who could address other resources that are potentially arising in the family.
Okay, do my colleagues have any further questions? Seeing none, thank you very much. We will hear from the department. And counsel, I would, if I may, could you start with the quote from the agency's attorney at the beginning of the trial? This is the one that Attorney Kaiser referred to. And I quote, "I would suggest to the court that the facts suggest a termination is appropriate at this time, irrespective of what's in the best interest of the children." what are we to take from this, where if there's one thing that is clear is that the termination decision turns on the best interests of the children?
Thank you, Your Honor. May it please the court, Adelaida Jaspers for the appellate, the Department of Children and Families. The department respectfully asks this court to affirm the decisions of the trial court in all respects. And I'd like to address your question first, Your Honor. I think we need to look at the findings and the evidence that supported the findings that clearly show that the termination was proper in this case. And that is for two main reasons. First, the evidence showed that there was little to no likelihood that mother would become fit. And that is because mother's parental pattern of parental unfitness was overwhelming, as shown by a constellation of factors, including the evidence.
Counsel, we hear you. Could you move on and address my question in terms of what are we to make of this quote and the attendant colloquy with the judge, where both the judge and the agency are emphasizing the time factor, and this case is over 1,000 days old. We need to resolve it. We need to move on. Help alleviate our concern that the best interests of the children were never entirely considered.
Your Honor, respectfully, seizing on that quote of the trial attorney for DCF, I don't think it would be productive when we have the findings of the court and when we have the evidence that the court relied upon and when we have the decision of the trial court.
Where is the analysis in the trial court's findings and rulings of law about the separate question of whether or not termination was in the best interests of the children?
The findings in totality, the court made 95 findings that are detailed and specific that show, first of all, the lengthy parental history of parental neglect, which began in 2007 and continued until 2018, where the children were placed in foster care. It also shows the mother's nearly 2-decade-long substance abuse, which was debilitating. Her mental health issues, which were intertwined with her.
Counsel, unfitness is not being contested. Neither are the findings that the unfitness is likely to continue into the indefinite future. What we're talking about here is solely the question of termination of the mother's rights. Can you point me to where in the findings or rulings of law that the judge wrestled with the question of whether or not termination was in the children's best interest?
Well, I think we have to look at the findings in totality, in aggregate, the findings and the conclusions of law. And the reason for that is that termination in this case served the best interest of the children because it allows them to maintain stability and permanency. And as the department's brief notes, this case is similar to adoption of Nancy, where the SJC, relying on Chapter 119, Section 26.4, held that long-term substitute care can be a permanent situation, while noting that the children termination allows the children permanency and stability. Here, the children are in a permanent and stable situation. The children do admit in their brief that their situation is stable. There was also in this case, it's worth noting that there was a dearth of evidence that a significant or positive attachment bond existed between mother and the children. In addition, if the mother's parental rights were not terminated, mother would have the right to petition the court every 6 months through the review and redetermination mechanism, which would further delay the children's chances for permanency and stability. In addition, DCF's plan for the children, as we know, is permanency through adoption, which cannot be implemented without the children, without terminating parental rights.
But you have a situation here where they're in foster care who has made a commitment to be there for the kids. So why isn't that a sufficient form of permanency, stability for the children?
That is true that the foster mother has made a commitment. However, as the court noted, the children have a right to and deserve permanency and stability, which would be achieved through allowing that option of adoption open for their future, for a brighter future as they navigate the twists and turns of the path from one family to another. And the children in this case, as Justice Milkey noted earlier, have the representation of counsel as long as they are in the department's custody. And they could, through the mechanism of review and determinations, but also the court, the trial court here through Chapter 11929B is required to conduct an annual determination of the permanency plan, which would also include a consideration whether it continues to be in the best interest of the children. To also note here that some of the arguments that my sisters made were that the children will become orphans, but actually the department, the SJC considered this issue of legal orphans in adoption of Nancy. And it found that children deserve permanency and stability, and would be facilitated by terminating parental rights. Indeed here, given mother's grievous—
Can I interrupt? Is the permanency and stability just the potential of adoption, even if it's a low probability that potential is sufficient to give them that permanency and stability that would equate to their best interest?
Yes, Your Honor. The children currently have stability, as we mentioned.
Well, in other words, there's a certain level of permanency and stability in the foster care, like Judge Singh had just pointed out.
Right.
And you wouldn't have to terminate the mother's parental rights to remain in that type of permanent, stable environment, to the extent that's permanent.
You would have, Your Honor, in this case, under the record showing that mother's history of grievous parental shortcomings, and also the fact that she has abandoned the children and the case by not visiting with them since 2018, and by—
We all accept that she's unfit. The question is, how is it in the best interest of the children where they are now in a stable, permanent setting to terminate the mother's rights? Your suggestion is she could come into reviews and things of that nature, but are you suggesting that's not in the best interest of the children, or that would be detrimental to the children? Or?
Your Honor, the termination and also the permanency plan that the court found in the best interest of the children allows them a broader range of options for the future by creating, as Justice Milkey said, a potential upside to finding an adoptive family. And
there were, I don't mean to keep cutting you off, but time is of a limit here. There were a number of family members that were inquired of and sought out. The record leaves us hanging in some situations where people never return paperwork and things of that nature. And I know it's to the extent it is outside the record. Was there follow-up on any of those situations, or is that, as far as you know, as the record leaves us here?
I know as the record leaves us here. I also know that the department's efforts are ongoing, Your Honor, as stated at trial. And the department's goal is to find a permanent placement for these children. And as earlier Justice Milkey said, these children are adoptable, and they are also bright and relatively healthy children, as the court noted. And also they have been doing well academically and behaviorally. So DCF's plan in this case, coupled with the evidence introduced at trial regarding children's needs, which is reflected in findings 39 through 52, allowed the judge to make a meaningful evaluation regarding the plans, and also allowed the judge to consider the children's wishes in finding 48. However, as we know, the children's wishes are not decisive, and they are not, in this case, determinative of their best interest.
Okay, but counsel, assume for the sake of argument that through a combination of the children's age, the fact that they're paired as a sibling group, the length of time they've been in foster care, and the objection of the children to adoption, in one case, veto, that they will not be adopted. So just assume that for the sake of this question. How is termination in the children's best interest? I can see how it might be in DCF's best interest, but how is termination helpful if you assume that they will not be adopted?
Your Honor, I think assuming that the children are not adoptable would perhaps invite impermissible speculation. However, for the sake of the argument, without conceding, if the children's, all of those factors are met, I would say that this plan and the termination of parental rights is in their best interest because, as I noted earlier, it allows the children a broader range of options. It does not foreclose their option of adoption. And also the fact that mother disappeared from the case indicates that this not terminating parental rights would give the children an illusory hope that mother would ever become able or willing to assume her parental responsibilities, which we don't have on this record. This is not a case where the parent engaged in services and met with the children, and there is a showing of significant bond where the termination would not have been in their best interest. This is a very different case, Your Honor. This is a case, as I noted, where the parent cut herself off the case since September 2018, since she conceded to her parental unfitness in September 2018. She did not engage in any services, and she did not meet with the children, even though she was provided with regular opportunities to meet with them. In addition, this plan, which is sufficiently detailed, allows the children a potential future or a brighter future that includes the chance at adoption. And that is something that the court did not abuse her discretion, the judge did not abuse her discretion by approving the plan and by terminating the parental rights under the evidence in this case. Why take that option away from the children? And again, the children are represented by counsel, and should they wish to petition the trial judge, if their circumstances change, they have the ability to do so. If I also may address one additional point. In their brief, my sisters referenced materials outside of the record, and they should not be considered by this court because they were never introduced at trial, and the appellants never showed how they would have been admissible before the judge.
But counsel, to some extent, the materials just go to issues like it's harder to adopt older children. Isn't that self-evident even without the materials?
Your Honor, every case is unique and also is fact-based. It depends on the children's individual needs, and these children here, as I noted, are bright, and they have done well academically and behaviorally, and they have forged healthy attachments with the adults in their lives as well as their peers. So I would not generate a general conclusion that because the children are older, they are less adaptable. And to go back to that, to the materials outside of the record, the department's brief cites to Commonwealth v. DeChica, where the SJC did not admit the article because it was not submitted before the judge and because it was objected by the Commonwealth, which is the case here as well. The department objected to that.
Counsel, isn't it true that your sister can point to many instances where the SJC has deemed it proper to rely on social science research outside the trial record?
Perhaps, Your Honor, but I also would like to mention that a panel of this court very recently issued a decision, adoption of Patricia, that was presided by Chief Justice Green, where the panel declined to accept articles stating that even putting aside obvious hearsay concern, they would not have been admissible absent appropriate foundational and substantive evidence. Finally, this court does not sit de novo, and allowing materials that were not before the trial judge would circumvent the standard of review and constitute impermissible error.
Okay, counsel, just one last time, give you an opportunity to help us address trial counsel's comment at the beginning of this case. Are you at least willing to say that perhaps he misspoke when he said this, or last opportunity to
Sure,
address a very troubling statement?
Your Honor, that perhaps might have been the case. It is an unfortunate statement, but I don't think that is the issue here. I think this court reviews the trial judge's decision for abuse of discretion or clear error of law, and where the evidence shows, based on the court's findings and the undergirded evidence, that the court did not commit error in this case. And the plans. Yes, Your Honor, I'm sorry.
No, I just say, do either of my colleagues have any follow-up questions? Seeing none, thank you all very much. Interesting, difficult case, which is now submitted. Thank you.
While the other...
only if there's background noise.
Okay. Thank you.
Are we online?
I believe we are. Just give me one more moment to confirm. Yes, we are live and on the record.
Thank you very much. We are back on the record for our fourth case of the morning. I think it's still morning, yes. 2020 P587, New England Bridge Contractors, Inc. versus Aspen Aerials, Inc. I would remind the parties that we have read the brief, so we're familiar with both the facts and the arguments. And I would urge both counsel to the extent possible, cut to the chase. And with that, I will turn the floor over to Attorney Almeida.
Thank you very much, Your Honor, and good morning, Your Honors, and may it please the court, Brian Almeida here on behalf of New England Bridge Contractors, Inc., the appellant in this matter. I certainly will do my best to avoid reiterating what's already been stated in my brief. I think that looking at this case from an overarching view, it does raise several different doctrinal issues that I think that we'll have the opportunity to discuss today in depth, particularly the doctrine of res ipsa loquitur, both as it's applied to these facts and also sort of the general theory behind it, the notion of the economic loss doctrine and its applicability both to these facts and sort of the general theory behind it, and also the doctrine of subsequent remedial measures as codified in Massachusetts Guide to Evidence number section 407. With respect to res ipsa loquitur, Your Honors, while the argument certainly was made below at least twice explicitly, but also sort of implicitly in the sense that New England Bridge's theory of liability with respect to negligence is that Aspen Aerials manufactured the A75 device at issue in this case, that the limit switches were installed backwards, and that nothing happened in the intermediate period of time that would supersede that theory of liability, that it was installed incorrectly. And I think that the first threshold issue that the lower court was misguided with respect to its decision is determining that there was no dispute of material fact with respect to whether New England Bridge altered the limit switch at any point during the intervening period. First, sort of focusing on the theoretical aspect of this argument is the notion that the time period during which New England Bridge had possession of the A75 was longer than the period of time in which Aspen Aerials had control of the device. And I would suggest to the court that the case law that I've cited suggests, particularly with respect to Wilson versus Honeywell, the SJC case that sort of enunciates the standard generally, gets into the concept that the theory of control doesn't need to be applied as strictly as I think that the lower court applied it. And I think that some of the other case law sort of speaks to this notion that it's less important when the period of control is as much as it is what occurred during that period of control with respect to the inference that's created by res ipsa loquitur, and then what, if anything, disturbed that. And I specifically refer the court to Evangelio, and even more specifically to a appellate division case, the Bruno case, which I cite in my brief, and I'm happy to provide the citation if the court needs it, which I think illustrates the concept that I'm seeking to sort of elaborate on quite succinctly, where in Bruno.
Counsel?
Absolutely, Your Honor. Yes, Your Honor.
As to the issue of raise of low order, you're going by inference, are you not, that the switches were manufactured or installed backwards by the manufacturer? There's no direct testimony to that from any source, is there?
Not testimony, Your Honor. I would refer you to a couple areas of the record. Well, first of all, Your Honor, there is the service bulletin that's the subject of the subsequent remedial measure argument.
Right.
Excuse me.
That I think that there was no. I mean, you're going by inference, correct?
The inference that Aspen was the one who installed it incorrectly. Yes, Your Honor. There are references in the summary judgment record that the limit switches ended up backwards. I think that's not really in dispute. It's just a question of how did they end up backwards. So I agree with Your Honor.
There's also evidence that they were altered by your client.
I would suggest that there isn't clear evidence on this record that that's the case. I think that
I can't think of his name. The principal for your client didn't he present testimony that he made alterations to those switches?
Your Honor, yes. You're thinking of John Wakis, and that was the contention of Aspen below.
He may have contradicted himself, but there were instances where he indicated they were set or reset by him or somebody under his control.
I think the confusion, Your Honor, is that, and I think this was a confusion that the lower court had as well, and perhaps even Aspen had, and maybe even myself, that there are a lot of different limit switches on this device. It's not just one limit switch. This has multiple turrets, and each turret has a limit switch, I believe, on each side that controls the direction of the movement inward and outward. And I can point, Your Honor, to a couple instances in the record, but specifically as to this limit switch, the one that's deemed to have failed, there is no evidence that Mr. Wakis altered that limit switch in particular. He does indeed concede that.
Isn't the issue not really whether he did do this to this switch, but that he could, that it could be done. It could be manipulated. It could be changed. Isn't that the real issue? After manufacture, after delivery to your client, it could be changed. And it could be changed, and it was in the custody and control of your client during this extended period of time.
Or in the same vein, that he not only at that point had control, but he exercised that control, regardless of whether or not he moved this particular switch. Once we're debating the facts of which switch was moved, et cetera, aren't we outside the world of res ipsa?
I'll attempt to address all of Your Honor's questions with a reference to one case, and that would be the Bruno case. And to just give you a recital of the facts of that case, it's a case having to do with a bicycle, where the handlebars, based on a manufacturing defect, failed 3 years after they had been purchased. And ostensibly, this person has been riding around on the bicycle for 3 years. And even though they had control of the bicycle and the ability to have ostensibly altered the handlebars, the bicycle failed 3 years after. And in this entire period of time, the manufacturer had no control over it. And the plaintiff in Bruno was able to succeed under a res ipsa loquitur theory. So respectfully, Your Honors, I would submit that the ability to make changes is not necessarily controlling, particularly with respect to those facts. And I think that case particularly relied on Evangelio and its progeny. And I do cite a couple other examples in my brief, albeit where the period of time is less attenuated.
Counsel, I'm not familiar with all the facts in Bruno, but on a manufacturer defect, I assume there was some expert testimony.
Yes, Your Honor. I can't speak specifically whether or not there was expert testimony in Bruno. I don't know exactly what the details were of that defect. But with respect to the issue of expert testimony, I would suggest again that, or perhaps I haven't suggested it yet, so I'll suggest it for the first time, that this is not necessarily an instance of a manufacturing defect that requires expert testimony. It's our position that the item itself is called a limit switch. It's designed to limit the boom from extending in one direction or the other, and it was installed backwards. If that's the case, I'm not sure what an expert would need to testify to. If a device that's called a limit switch that limits the movement is installed backwards, I think that's within a jury's ability to understand. Certainly, if it were a more complicated manufacturing defect that required additional discussion as to how the device operated, sure. But in this case, it's within a jury's understanding that if something's installed backwards and it fails, that's negligence.
I'm not sure that installing something backwards would necessarily mean backwards or upside down, that it would necessarily mean that would create some sort of a problem. You've got to, let's take a doorknob. It's got a function, but you could install a doorknob backwards. It would still function. So I don't think one relates to the other, that if something is installed backward, it necessarily would be faulty.
I concede, Your Honor, I don't know enough about doorknobs to know whether or not installing it backwards would work. I'm sure I've installed a doorknob backwards in my attempts to fix my or paint my doors. But respectfully, Your Honor, I think that if you install something backwards and it fails, and then we also have to turn to some of the other evidence with respect to the service bulletin, there's a concession that it was wrong. I think that a jury can get there, particularly when it does indeed fail.
Not if it's a subsequent remedial measure, right?
Well, of course, Your Honor, but I sort of playing that argument out, I think that a jury wouldn't necessarily just be given it was installed backwards, period. They'd be given it was installed backwards and it failed by tipping in the exact manner that would have been prevented if the limit switch had been working. Certainly something that's installed backwards.
Isn't that bulletin by almost by definition, by its existence, a remedial measure? How do you say them putting that out after it was reported that to check your switches, not a remedial measure?
Well, in two ways, Your Honor. I think that first, and I admit that the case law on this issue is rather sparse, both with respect to this particular discrete issue and also just the doctrine in general. Most of the case law that I found just sort of states, here's what 407 says, it fits under that definition. There hasn't really been an exploration of this, but at least conceptually to me, there's a distinction between the actual remedial measure and an announcement that something that's gone wrong. I certainly agree that there's some connection between the two, but at least from my understanding, the subsequent remedial measure here could be the actual repair kit that we can't get in front of a jury and say, well, or the fact finder and say, well, this is how they fixed the problem. Clearly there was a feasible alternative design or any number of things.
Counsel, I think frankly you may have it backwards, because there is an exception to the rule that says if there's a debate about the feasibility of a fix, then there's an exception to this, that you can get that before the jury. But in terms of the efforts by the jury to call people's attention to the problem, I'm having a hard time seeing why my colleague is wrong to say this is the very definition of a subsequent remedial measure.
Well, as to whether or not this would have fixed the problem. I think necessarily, I guess the main grievance that New England Bridge has with respect to this issue is that it was raised essentially for the first time, or let me correct myself, I believe for the first time, by the summary judgment record is silent really as to whether or not this actually would have solved the problem. And the second issue is that in addition to identifying the issue for the first time, I did refer to my brother counsel's comments on this issue at the summary judgment hearing. He was quite equivocal as to whether or not this would solve the issue. He said, well, this was done prophylactically. We didn't think there was an issue. We thought that New England Bridge might have altered it, but we did this just to be safe. So that's the issue as well, is to what extent can a party sort of repudiate whether or not something is a remedial measure by saying, well, we didn't really do it as a remedial measure. If Aspen comes out and says, yes, we did this as a subsequent remedial measure, that's one thing, but I don't think that's what happened here. So I think that's the argument with respect to subsequent remedial measure in truth is, can a party, there has to be a causal link between the thing that goes wrong and the measure that you're putting in place to fix it. And I believe in this case, the party itself attenuated that connection.
Isn't that why God invented expert witnesses?
Well, Your Honor, I guess that's fair. I don't think that necessarily speaks to the notion of a party can repudiate their own subsequent remedial measure by saying we didn't do it as a subsequent remedial measure. We did it just to make sure this problem wasn't elsewhere. And then
But that is what a subsequent remedial measure is, to protect against future issues.
But that's true, Your Honor. But in fairness, doesn't it require some knowledge that there is an issue, or is before the lower court?
Do either of my counsel have any further, my colleagues have any further questions? Hearing none, we'll hear from Attorney Smith.
Good morning, Your Honor. Good morning, panel. Michael Smith for the appellee Aspen Aerials, Inc. Your Honor, I'll take your advice and cut right to the chase. There's really two issues that drive the analysis on summary judgment here. And they are the damages sought in this case, which are purely economic damages for lost profits that the plaintiff claims he lost for a period of 61 days. And the nature of this transaction, which is the sale of the A75 that was consummated in August 6th of 2010, when NEB came to pick up the A75. Just briefly addressing the issue of res ipsa and the record before this court at summary judgment, I would submit to the court that the only evidence and that what's agreed to on this record was that at the time of manufacture, when the A75 left Aspen Aerials, there were no defects found with any of the limit switches. Aspen Aerials did a complete examination of the A75, and that's a joint appendix, volume 1, page 27, agreed facts number 63, which the plaintiff agreed to. So on this record, there is the only evidence is that there was nothing wrong with the A75 when it left Aspen Aerials. And for the next 6 years, it was the plaintiff who was charged with the maintenance and following the manufacturer's recommendations and the use of this, the A75. Res ipsa, the cases are clear, say that in order for res ipsa to apply, the instrumentality has to be in the control of the defendant. Here it's the opposite. It was in the complete control of the plaintiff for 6 years. But even if this court were inclined to entertain a res ipsa argument, it fails because of the economic loss doctrine. The economic loss doctrine precludes his negligence claim, the plaintiff's negligence claim in this case.
Could you just clarify one thing for me?
Sure.
There were issues regarding damage to a bridge and damage to a truck. And I understand the bridge didn't belong to the plaintiff, but the plaintiff had to pay out on the bridge damage, right?
The plaintiff did not pay out on the bridge, but there was damage to the bridge. Okay.
And was the truck part of the product?
Yes, Your Honor. Okay. It's a truck that comes and we mount this large under bridge inspection. So it's like
the truck is their property.
The truck,
they bring the truck to you and you install the unit. So they're two separate. You didn't sell them the truck. The truck is a necessary component, but it's their property. They could have probably had it put on a different truck at a later date if they needed to.
I suppose that's true, Your Honor, but I would suggest that the damage to the truck is not part of the damages in this case. The plaintiff is not seeking those damages. The plaintiff does not have a right to those damages, and they're not part
counsel, why wouldn't the plaintiff have a right to those damages under the collateral source rule, where courts ignore the fact that an insurer has paid out?
Because I don't think that the collateral, once they get paid by their insurance company, they lose those rights to those. And the insurance company brought a subrogation action for those very damages as part of this claim, which are no longer part of this case. So I don't think the collateral source, he doesn't own, once they get paid by their insurance company, they don't own the rights to those property damage claims anymore.
No, but as you point out, the insurance company can recover it through subrogation.
But then it's a double recovery, Your Honor. The insurance company paid them for them. The insurance company gets reimbursed for it, and then the plaintiff then cannot go seek those same damages under subrogation.
No.
Because of
no. If the insurance company paid out damages to the bridge, and then went after New England in a subrogation action to collect those damages, New England's out of pocket those damages. Is that? I think that's where you were going.
No, what I'm suggesting is that when the insurance company pays New England Bridge, and then the insurance company goes after those damages in subrogation, New England Bridge no longer has those rights to those damages.
Are you saying that that's already happened?
Yes.
Okay, when did that happen with respect to this? You said it was part of the same litigation?
It was, Your Honor. Commerce Insurance joined as part of this litigation, and it resolved before the summary judgment motion.
Before summary judgment, okay.
Yes, Your Honor.
So Commerce came after you to pay them for the cost of repair for the vehicle?
Yes, Your Honor.
All right.
And so once that resolved, any New England Bridge has no right to those damages anymore. Can't bring those claims. So really, we are here only talking about the lost profits. And as the Bay State, the economic loss doctrine has been long recognized in the Commonwealth, and I think the Bay State versus Caterpillar case is right on point with the situation we have here. In Bay State, the court said the economic loss doctrine recognizes a meaningful distinction between tort recovery for physical injuries and warranty recovery for economic loss. When a product injures only itself, the reasons for imposing a tort duty are weak, and those for leaving the party with its contractual remedies are strong. And that's exactly what we have here. So while I disagree, and I think I'll rely on my brief as to the arguments of the res ipsa, I think that the nature of the damages the plaintiff seeks in this case preclude it from having a negligence claim. And I'd also say the record in this case doesn't establish any sort of negligence. So that, and I guess I'll segue from that point to the statute of limitations argument, which the lower court properly found on the implied warranty of merchantability claim. GL 2-725 is applicable to this case. There's no dispute again here that this is a case that involves a contract, the sale of the A75. Again, the nature of the damages, which are only for loss of use, are make it so that the applicable statute of limitations is 725, not the tort-based statute of limitations in 2-318. And I think the Bay State case really gives a good explanation about the reasons behind it. And in fact, that's what the whole case talks about, is that the statute of limitations on a tort-based remedy for a consumer who didn't have the opportunity to negotiate or have any involvement with the product that injures them, well, then the policy behind that makes sense, that they should be able to bring a claim once the injury occurs. But that's not the case when it's a contract-based claim for an implied warranty, which is what we have here. As the Bay State court said, there's really no reason why that the tort-based statute of limitations would apply. And my brother's only argument that I read from his brief is that he cites to I believe, a First Circuit case that sort of had to do with intellectual property, and there was a number of claims. And I would suggest that's not. I would suggest that Bay State is the controlling authority in the Commonwealth. And I think the Bay State court actually dealt with, in footnote 8, actually dealt with the statute of limitation argument, where it says we would also reject any suggestion that the statute of limitations of 2-318 would apply to an original purchaser's contract-based claim for economic loss as well. To so rule would mean that the insertion of the statute of limitations in 2-318 impliedly amended almost to extinction the statute of limitations of 2-752. So and there's no dispute again on the facts here, that we know that under the UCC that the breach occurs when the tender occurs, which Again, it's stipulated in the record that that was August 6th of 2010. They didn't file suit until March of 2017. The claim for the plaintiff's claims under the implied warranty are time barred. Now, addressing the issue that was never the lower court, and I would suggest that the lower court was correct that the economic loss doctrine and the statute of limitation are sufficient to dispense with the plaintiff's case claims in this case. However, equally so powerful, if you will, I missed a word there, is the fact that there was a 1-year warranty with respect to the purchase of this A75. The record is clear that this plaintiff had purchased 13 different pieces of equipment, all done the same way, all with the same warranty. They get, when they get a quotation, it references the 1-year warranty. They get a CD that contains the warranty. They get a hard copy of the operator's manual that has a copy of the warranty. The warranty, Your Honor, is at Exhibit Q in the record appendix. And again, this plaintiff on this very machine, on the A75, made 11 claims under the warranty.
Is any of that disputed?
That is not disputed, Your Honor. In the joint statement of facts, again, joint appendix volume 1, in facts 37 and 38. I'm sorry, Your Honor, that had to do with the warranty issue. 72 and 73 on pages 29 and 30 of the joint appendix volume 1, Your Honor. So we have a situation here where the plaintiff knew about the warranty, they made claims under the warranty, and then counsel admits for the first time really at the oral argument that yes, we got the warranty, we know it exists, we know we can make claims under it. So there's no dispute that they got the warranty. And in addition, Your Honor, on this record and the joint statement of facts, the plaintiff concedes that the warranty properly disclaims all of his claims in this case. It properly disclaims negligence. It properly disclaims all implied or express warranties other than the 1 year. That again, that's not disputed. So we have, based on the undisputed facts in this case, a 1-year warranty that the plaintiff knew about, that he made claims under, and that it terminated as all of his claims in this case as of August of 2011. To suggest, really my brother's only argument in this case was that Aspen had some sort of, or the UCC somehow required Aspen to call up New England Bridge and say, hey, did you read all the terms of this? Despite the fact that you are making claims under it and you've done that 70 times over the year and 11 times on this piece of equipment, hey, do you understand all the terms? The UCC doesn't require that. The UCC requires that in order to disclaim the implied warranties or any warranties, it needs to be conspicuous. It's stipulated that it is, and it has to be in bold-faced writing. It is. So, Your Honor, I would say that clearly the 1-year warranty dispels of all the plaintiff's claims, along with the economic loss doctrine and the statute of limitations under 2-725. And if there's no question, I'm sorry, go ahead, Your Honor.
No, just checking. Do either of my colleagues have any follow-up questions? I think that's your answer, counsel.
Thank you. Thank you for your time.
Thank you both very much. The cases are our fifth and last case of the day. It is 2020 P760, Alexoff versus Alexoff. And I just want to remind the parties that we have read the briefs, so we are familiar with both the facts and the legal arguments. So I would urge counsel to the extent possible, cut to the chase. And with that, I will turn it over to Attorney Alexoff.
Thank you, Your Honor. Chris Alexoff for the appellants, and I will take your advice and be very brief. In the last 100 years, there's not been one case under Section 2 or Chapter 230, Section 5, where an alleged heir had standing to bring claims personally held by a testator. I haven't found one. And there's not one in the appellee's brief.
Can I ask you a question?
You can.
You're appealing the denial of your special motion to dismiss of count 5.
That's correct.
Just count 5.
It's count 5 was the declaratory judgment action, and the other. It's not clear what other, because of the way the complaint was set up and the claims were brought the way they were. It's not clear which other ones supported. But nevertheless, it's the same argument for any claim that would have been.
Well, I guess my question is this. We can address count 5. You're raising a standing argument as to the entire complaint, though.
Indeed, you're right.
And
except for
I don't know.
4.
And under what authority are you raising standing as the entire complaint?
Well, Your Honor, I think, excuse me, I didn't mean to cut you off.
No, just, I mean, there's been no final judgment. There was a ruling on count 5 only. So
Sure.
Are we limited on this appeal to make a determination as to whether or not the judge properly denied your special motion to dismiss as to count 5?
I think because the issue is one of subject matter jurisdiction, that issue can be raised at any time by any court.
It can be raised at any time, but it's not an appellate issue interlocutory until there's a final judgment, is my understanding.
Sure, but this is it. So the issue we're dealing with is the list pendants entirely. The issues about the real property, I mean, that's kind of what we're talking about here. And there's no allegation in the complaint in count 5 or otherwise, which would say that the plaintiff in this case is entitled to that property, right? We have a will contest.
I agree that the issue is intertwined, but as far as a procedure, I'm understanding this appeal to be limited to count 5.
And I understand that as well, Your Honor, and I think that is the count that supports the list pendants.
All right.
So that is my understanding as well.
But it would, in other words, if we agreed with your argument and count 5 should have been dismissed, the other counts still remain.
I think potentially that is true, Your Honor. But at the same time, I mean, that is the way the statute is set up. Correct.
Okay. All right. I just wanted to make sure I was clear and that was what your understanding was, but
it is mine too. And even though as you pointed out, the arguments are the same for any other claim that was brought that way.
Now, counsel, as I understand your argument, you're saying that count 5, at least as pled, had to be brought by the personal representative of the estate. Your mother is not been appointed PR. Ipso facto, she cannot bring count 5 at this time. Under circumstances where the question of whether or not she is appointed the PR is tied up in the probate court action, what is she supposed to do? I mean, under the case from her perspective, it makes obvious sense for lease pendants to go on the property and to preserve the status quo while all these different suite of issues are fought over. So again, under these circumstances where the PR issue, she's trying to be appointed PR, but that issue has not been resolved yet. Shouldn't there be some process where someone in your mother's position can file a lease pendants?
I think, I mean, this is getting outside of this case, but in the probate court, the probate judge has the same power to enjoin any, could grant a lease pendants as well. Or this action could have been joined with the probate action. The issue, I think, is really that there's a mechanism in probate through a special personal representative, which you're supposed to actually have appointed if you have issues like these, right? Because that is the person who is going to represent the estate, the best interest of the estate. Right now, we have a case sitting in the Superior Court where if, let's just say there could be a judgment against me in favor of personally Aisha Alexa having nothing to do with the estate. And then the estate could come out the other way. It could give everything to me. And then we have these two judgments here. I mean, that's the whole issue when you get it's fundamental. Standing is just the fundamental issue here, and there's no standing. I think, and I hope I answered your question. I don't know if I did, but.
So well, is the answer to my question that you're saying your mother should have filed for lease pendants in probate court?
That's one option. The problem is the complaint that supported it doesn't say that there was any harm caused by the defendants to her. They say that the harm was to a non-party, a necessary party in this case, the estate of Mr. Khan, who has not been added, and at this point probably won't. I mean, has not been. 2 years later.
But getting back to my question, putting aside issues of form, why doesn't it make perfect sense that there be a lease pendants on this property pending the resolution of the probate court action?
Because I understand your question. What is her? I mean, these were claims that should have been brought in probate court. I'm sure a probate court judge would have handled them the way they were supposed to be handled. I mean, the point of the matter is there is no right to property by her at this time. And any right would be vested in the estate, which is ongoing.
No, but this appeal at least is solely about the lease pendants, isn't it?
Sure. And I get that, and I guess I don't understand. I think I understand what you're saying, but what? But
I'm saying if it makes sense to have a lease pendants, and the best you can argue is she should have sought such relief in the probate court, then why are we fighting about this?
Or join the proper party, because we're gonna end up in a situation where we're in a situation now where the interests of the estate are what are represented by Section 235. That's what the statute says. You bring an action on behalf of the estate, right? And for the court to then say, well, she is standing under the statute to bring these claims on her own behalf, I mean, there's just no case law that supports that.
Well,
it's not.
But how does there's no question there's litigation over this property, correct? Whether it's by the will contest or by this complaint, there's clearly litigation over this property.
Yes.
So that's all the list pendants is telling the public. There's litigation on this property. How is that? Is that other than the issue of standing? Is that causing? Maybe I'm going outside the record here, but is that causing prejudice or damage to anyone by having the list pendants present on the record?
Well, certainly. I mean, this property could have been, refinanced for a mortgage. I'm currently paying the mortgage. There's work that needs to be done on the property. There's insurance proceeds that are sitting around that can't be used to repair the property because this list pendants is in place.
Well, first of all,
the fight over whose property it is.
I mean, the list pendants doesn't prevent any of that from happening.
Well, it prevents the refinancing of the property. Certainly.
Well, they may want the list pendants lifted so they're ahead of it.
Mm-hmm. I mean, in my experience, that banks won't. If there's a list pendants, banks aren't going to deal with the property. But I mean, that's kind of where we're.
All right. I mean, it just seems as though we're fighting on standing and not the presence of the list pendants.
I think they're intertwined, Your Honor. I mean, there's case law which I cited that supports the proposition that if a party does not have standing, they can't seek and get a list pendants. I mean, I think in Gallup they talk about the same issue here. They were fighting over the property between two different condo owners, and because there was no standing, because the plaintiffs didn't have an actual, I guess, foot in the game, so to speak, there was no standing. They dismissed the claim that was supporting it. I mean, in this case, in either way, there's going to have to be a substitution here, at least of the estate, in order to proceed on these claims. I mean, I don't think anyone disagrees with that. But the whole point is, I mean, that could be entirely moot, depending on how the outcome of the underlying probate action.
And what's the status of that?
We finished 4 days of trial, and we were waiting for the decision.
And that was back in December?
I believe our last day was in December or January.
Around the first of the year.
Yeah.
And there's been no report from the court?
None to speak of.
Okay. Go right ahead. I don't mean to keep interrupting. Go right
No,
ahead.
no, it's fine. And so I don't have much more. If there are any more questions you would like to ask, I understand the points you're coming from, but I mean, the appeal is, we're left with what the judge decided the case on and the parties in the case. I mean, it's not the way I would have done about it, but
I mean, my interpretation, as Judge Wilkins said, for purposes of this Liz penance minimally, that your mother had, I just don't know her full name, so I don't mean the other party, had standing under 230 section 5.
I think I understand that was what he stated, but I have not found one case, nor has anyone else cited a case that would support that.
But it's clear that she's attempted to become the personal representative under one will.
Yes, and
you blocked that by, or she's blocked your right, vice versa. You're both attempting to become personal representative.
Sure.
So Judge Wilkins was stuck with a situation of looking at, I'm just issuing a Liz penance for now because they're fighting each other as to each are preventing the other from becoming personal representative.
In a property that I own, yes.
That you assert you own.
On record, I own.
Yeah, counsel, when this was argued in Superior Court, did you say, oh, she has a proper procedure, it just has to be in the probate court?
I mean, that issue was brought up, and you can read it in the argument that was discussed between the parties. And I certainly didn't block any transfer or even object to it. I suggested it before. The point of the matter is we have a person who's representing the estate, allegedly, but seeking personal private damages for the harm caused to somebody else. And I think that's the real issue here. I understand the court's point about there could be a lis pendens anyways, but I mean, it's not incumbent on the defendant to make sure that the plaintiff goes through the proper procedures and makes the proper arguments and joins the proper parties to the case, especially when the estate can't be joined because there's no personal representative, when there are mechanisms to use to bring in the estate in this case. I mean, it's black letter. It's 230 section 5 says there has to be an administrator or a personal representative for standing for an heir to bring anything.
We don't have a personal representative yet because there are dueling unresolved claims to that status.
Sure.
So again, I hear you on perhaps this should have been filed in probate court, but I'm wondering to what end if you're not really contesting the idea that somebody is entitled to a lis pendens to let the public know about the competing claims on this property in litigation.
And again, I am contesting the lis pendens because she has no interest in this property yet. She has not brought a claim either in this court or the probate court that would entitle her to possession of the property. So I don't.
Is that really fair? I mean, she's claiming that she's challenging the transfer of the property, isn't she?
I mean, apparently she's on behalf of the estate. She's attempting to personally claim that she was harmed. I mean, it just doesn't make sense. The way the complaint is set up is it would give her possession and ownership of the property when the outcome of the probate litigation is.
No, but she's claiming that the transfer was fraudulently made to your name, and then she's claiming that under the will that she's seeking to probate, that it would have been left to her. So to prevent any either waste of property or sale of property or abandonment of some sort, she files a lis pendens and gets the injunctive relief that Judge Wilkins ordered. So it's clear there's some form of litigation that has, I can't talk to its merit, but there's a recognized cause of action that's being filed. I understand your argument that because she's not a personal representative, she has no standing. I understand that. And that's the kind of issue, the issue we have to grapple with, but she's attempted to become personal representative. You're saying there's another procedure where a special representative can be appointed through probate court?
Absolutely. And that's a step they could have taken. They chose not to, probably because of the issues that would have been raised. Frankly, as a condition precedent to her having any claim to these properties, she has to be, her will has to be probated and found valid. And on the
Her
contrary,
position also is that she, under even if everything was invalidated, she's the heir, right?
yeah, but
She's got another avenue.
we're speculating as to what may happen down the road, and standing requires a concrete injury here, right?
Okay.
An actual controversy, which only comes into play if she's successful in a different lawsuit.
Okay, counsel, I think we understand the argument. Unless my colleagues have any follow-up, we will hear from the mother's attorney.
Thank you, Your Honors. Mark Chapdelaine on behalf of Aisha Alexov. First, as was cited both in the Superior Court and cited in Attorney Alexov's brief, Labonte versus Giordano states that if the administrator or the executor is unwilling to bring a claim, then standing may come into play. Then an expectant heir would have standing to bring a claim, such as here. We have an interference with testamentary gift claim here. Clearly, Attorney Alexov objects to bringing any such claim. As such, we would get over the hurdle of standing. I do want to get into, however, the reason why this case was not brought in the probate court. And the reason is because Attorney Alexov's dealings, which are articulated in the complaint, the verified complaint, was that he held on to these deeds until after his grandfather's death to record them.
Isn't that true? One of the deeds, not the other.
One of the deeds. The other deed, correct. There's also issues with the notary that they were both notarized. So I'll use that term loosely, without Mr. Alexov, the deceased Ronald Kahn, rather, being present. He was not present before the notary. It was at Attorney Alexov's direction that a friend of the family notarized these deeds without the now deceased present. But because these deeds, these properties, were taken out of Mr. Kahn, the late Mr. Kahn's name, and placed into Attorney Alexov's name, whether it be through a single member LLC or his name individually, they were no longer assets of the estate at this moment in time. Certainly, once we get the decision from the probate court, we fully expect that either the 2019 will be allowed and it will appoint Aisha Alexov, or both wills will be stricken and Aisha will, through the law of testamentary proceedings, would become the lawful heir as the sole daughter, the sole child of the late Ronald Kahn. So we expect that to happen, but these properties were not brought into the probate court because they were taken out of the estate. So that's why we have this secondary action going.
It wasn't put in the name jointly? Was it?
One of the properties was. The other property was placed into an LLC.
Okay, so, all right. I was under the understanding that both properties were replaced in joint ownership.
One property, 224, was placed in Ronald Kahn and Christopher Alexov's name as joint tenants, and the other property was granted to 28 Bradford Street LLC.
Okay, thank you.
So just if I could interrupt, the issue, as I went through with Mr. Alexov, Attorney Alexov, is whether or not count 5 survives his special motion to dismiss. His primary argument here is that there was no standing and therefore it shouldn't survive because it shouldn't have been brought. Your position is that the Labonte versus Giordano case provides that standing necessary. Shouldn't that be the end of the argument?
It should. And I will also point out that many respects, Attorney Alexov, certainly the Superior Court, relied on 81 Spooner Street versus Town of Brookline. and a litany of other planning board cases, which under 40A appeals, standing is a much different person aggrieved issue than we have here. But I'd also point out that even if count 5 was stricken, which I certainly don't think it should be, I think it is absolutely a proper count here, and we do have standing to bring this count. But the lis pendens, which is the crusp of the special motion to dismiss, would still survive because of the claims raised under the fraud argument, which Judge Wilson found was properly pled and pled with specificity, which claims that the deeds were procured through fraud, and as a result, that a constructive trust should be created, and the deed should be changed to the estate, essentially. So it is something that even if count 5 was stricken, the lis pendens should still survive, and the special motion.
Counsel, you appear to have frozen.
Believe that count 5 is a valid count, and do not believe that it should be dismissed by any stretch.
Counsel, you are frozen
for about 10 seconds.
For about 10 seconds.
I made some great points during that period.
I think it actually caught up with you, but anyway.
Excellent. But the count five should certainly, still remain. But even if it didn't remain, that the fraud count would still give us reason to have the lis pendens in place, so the world's on notice while the title to these properties are in dispute.
Maybe I misread it, but it was my understanding, at least from Attorney Alexov's complaint or argument, was that count 5 was the only count that would have attached to a lis pendens, and therefore that's why he's attacking count 5, because if count 5 goes, the presumption is the lis pendens would go as well. I mean, that was my understanding of reading the argument.
Well, count 6 is tortious interference with expected inheritance against all defendants. I think that certainly goes towards the argument that these properties should not have been conveyed to Mr. Alexov and an LLC that Mr. Alexov is the beneficiary of. And just one point that the 224 West Plain Street, that was to Mr. Alexov and Mr. Khan, but that was as joint tenants. So certainly by Mr. Khan's death, Attorney Alexov becomes the sole owner. But in addition, the undue influence claim and the fraud claim would give rise to a dispute over a title to real property, where the lis pendens would still be an appropriate memorandum to have endorsed at this time. So I think it is also important that we look to what Judge Wilkins' order was, and what facts he found in a very short order that weren't addressed in Attorney Alexov's brief at all. He says the complaint sufficiently alleges coercion, fraud, or undue influence by Chris Alexov on February 26, 2019, as well as Mr. Khan's protest April 1st, 2019, and unexplained delay in recording the relevant allegedly fraudulent deed until after Mr. Khan's death, when nothing could be done short of this lawsuit. Those are important facts to have been found that support Judge Wilkins' basis for denying this special motion to dismiss.
A special motion to dismiss, what's the standard of review? Is that de novo?
It would be, for your honors, it would be de novo review, as pointed out in our brief.
In lis pendens?
The lis pendens would be, we simply need to give a statement of claim to title to real property.
Is that a de novo review, or is that a abuse of discretion, or?
Respectfully, I don't know. I think if the special motion to dismiss has de novo review, then it would fall under also de novo review, because the heart of the special motion to dismiss is whether or not the lis pendens is devoid of a basis in fact or some issue of law. But I think we get over both of those hurdles here, and I think the basis of which Judge Wilkins found are applicable here, and it's something that I would ask the appeals court to consider when making your decision, because I do think he got it correct. Certainly the standard is not clearly erroneous, but I think he got it right here, and I asked the court to to keep that in mind when deciding this matter, albeit de novo.
Do either of my colleagues have any further questions? Counsel, you have 5.5 minutes if you want, or you can submit on the briefs.
I'll submit my brief and my arguments to this point, and if there are no further questions, I know we're a bit behind today, so give you your 5 minutes back.
Yeah. Thank you both very much. The case is submitted.
Thank you very much, Your Honor.